Charlotte, that brings us to some practical guidance. We've got some practical guidance that's been issued on our slides. And have you got any thoughts about that, the practical guidance?
I think it's very, very sensible. I mean, there's going to be a transition. It is going to be, realistically speaking, you're quite right. It's going to be delayed. If you look at what happened in England when the Children and Families Act came in, it took years for everybody who was on a statement to be moved over to an EHC plan. It took much longer than people expected, and there were various target dates for everybody to be moved over, which were missed, as I'm sure we all remember. And so I think in the meantime, pragmatism is the way forward. So I think absolutely yes, if it's not broken, don't fix it. If what you've got at the moment is working, let it continue. Let it continue. Let your school or college or local authority come to you in their own time and organise the transition, because if you force it, there is a real risk that you will end up with something that doesn't work as well as what you've got now. If it's not working well, then you need to address that, and you would need to address that whether we were in the middle of this statutory transition or not. And I think it's right that a new assessment is always going to benefit a child or young person. If things are not working out for them, it's really, really important to understand why and to update that provision. And you can add that to your IDP, or you can add that to, you could add that to a current statement, I suppose. If the young person is turning 19, that's the big one, isn't it? Because if the young person is turning 19, that's where this statutory regime makes a real difference for them. And I think I would agree with the advice here, because it would make sense for young people to be prioritised in terms of transfer, because they will be young people who either don't have any kind of existing plan, or whatever plan they do have will be coming to an end for them under the current regime. So if you are if you haven't had confirmation of this from wherever your young person is being educated, or whoever is responsible for their plan, then, as it says here, once the Act is fully implemented, you should request an assessment. And I think, Mike, we say that, don't we? Because, again, we don't really want to rush an assessment that is not properly thought out and causes more problems than it solves.
Yeah, I mean, Charlotte, you probably know as well as I mean, I was looking at an education healthcare plan the other day. It was extraordinary because that was rushed, but all the provision was set out in outcomes. There was nothing much left in the section F. It was all under the outcome section. So really, we're seeing. The other thing I was going to say is that I think practically, and a good thing, is that we've got a much more a concrete system. We've got one plan that the Welsh Government has suggested in the Code of Practice that must be followed by all. I think I agree with that, because we saw chaos in 2014 when the Children and Families Act came about. So I think that, but rushing things doesn't give you much benefit. Chris, any other thoughts?
No, absolutely right. I think you're quite right there. I think one of the things that I was slightly surprised at, and of course, when preparing the slides, obviously we were anticipating that there would be more of a focus on those turning 19. And I suppose when you look now at the implementation plan that we looked at earlier, they're actually not specifically referred to. So I think it's quite good that we've advised people here to be a bit more proactive, because of course, when you're coming to the end of your school time and you're transitioning to college, certainly if you've had a statement up until the end of your education, you're still going to need one of these plans, once you go there. So it's good to be a bit more proactive. I think those are the people who probably should have the most vigilance in terms of transitioning over, because this statement can't go with them. If they reach the end of the school year in which they turn 19, the statement will lapse. Likewise, if they go to an FE college, the statement will lapse. So for those young people, it's important that they are quite vigilant. For everyone else, as you say, you can make the judgment call. If you're happy with your statement, then definitely, wait and wait for good time for it to come along. And I think that's really helpful. So yes, I mean, as ever, it will remain to be seen, and it will take some time for people to be transferred over. But I think, like with the Children and Families Act, there will always be some teething problems that perhaps we couldn't anticipate at this stage. But I think now, when we look back at the Children and Families Act, because it's 7 years now, but I think it's been this way for a couple of years, it did settle down quite quickly, and I think worked quite effectively quite quickly. So I'm hopeful that this Act will remain the same.
Well, it's interesting that, Chris. I mean, you're right when you talked about the implementation, that the young people at the age of 19 are not really mentioned. Is that perhaps to do with the fact that buried deep in the Welsh Government website is a series of technical guidance issued to specialist colleges that appear to suggest that once you have your 2 years post-schooling, then that is your lot. And I think that a lot should be gleaned from the implementation slide that you very kindly produced, about that what we are actually seeing is that the Welsh Government's approach is to implement that technical guidance, and that many young people at the age of 18, 19 might still go without under the current regime, but would probably practically, unless I'm mistaken, be advised to try and get the IDP drawn up for them sooner rather than later. Chris, do you agree with that?
Yes, I think just simply yes. I think that's it's always good to, as we've been talking about, you've always got to look at your situation and whether you're going to be better off, having the plan or not. And certainly if there is uncertainty, as we talked about earlier, if you're lapsing out of the current system, or if you're transitioning to a new system where historically you would lapse, then certainly I think it's worth your while requesting the decision. And of course, you do have that right. So I think it's really important, as we talked about earlier with the implementation, that's how they're going to be rolling out. And we all agreed it was pretty reasonable, the strategy and the people they were going to focus, because they were generally at transitions. And they talked about at this stage that they aren't focusing on those in post-16 education for the first year of implementation for that more general rollout. But that does not prohibit people from requesting that decision and using those rights under the Act at any time they like. They are rights, and there are duties upon those institutions that will come from the 1st September. So it's always a personal decision to make. But certainly if you have concerns, you feel there's uncertainty, then transitioning to a plan as early as possible might be the right choice for you. So take advice if you need it. We're always here to help. But certainly make those decisions that are in your best interest. And
if you're a college out there, I'm sure you'll want to have a crash course. And,
I'm sure.
Charlotte's here. Charlotte's here welcoming.
Absolutely.
Charlotte, you're going to be up many nights giving colleges crash courses. You know that, don't you?
Times, yeah.
You do realise sleep is not going to be part of your daily regime.
Justice never sleeps, Mike.
Justice never sleeps.
It doesn't in my house anyway.
Well, that brings me. I think to the stage of the questions and answers. As of course, many of you have presented questions for us as a panel to answer. So we're going to get to that phase now of our presentation. So here are the questions.
So our first question is about the nature of IDPs and reads, will an IDP assessed and issued by county have the same weight as a current statement? And will my son continue with his statement provision when all children or young people are switched to IDPs? Well, answer to the first part of that question, yes. The whole purpose of an IDP, certainly at county level, is that it will work in exactly the same way as a statement. It will be managed and implemented by the local authority, and you will have an enforceable right against the authority to implement that provision. So very much the plan is to keep the status quo in terms of the strength of a plan versus a statement, even if the format is slightly changing. And of course, the content of a statement shouldn't necessarily change unless, of course, the child's needs have changed. So you shouldn't see a reduction in provision generally. It should only be if the child's needs have changed since the statement was last written. So in terms of this listener's son, I would like to think that his statement provision will stay when he's switched to an IDP. But of course, if there are any amendments that you are unhappy with, you will have the opportunity to go to the tribunal as you would normally. But our anticipation is, and certainly in practice it was with the Children and Families Act, that actually, because there was such a pressure on transitioning pupils to the new form of plan, then actually a lot of statements were just transposed straight into education healthcare plans with very little amendment. So we think that'll generally be the case here, although of course there will be exceptions where changes are proposed. Some of those may be great and some of those may be welcome. Some of those, of course, may be less welcome, and some may need to be challenged to tribunal. But until such time as he switched across, his statement will still in force. And when he is switched across, his provision will usually follow with him, less amended, and it will be enforceable after that as well. So no change anticipated. Our second question is from an expert, an occupational therapist, who says, my question is what impact the law changes will have on therapy provision. Currently, I'm contracted to provide therapy as an independent practitioner by local authorities when the local teams don't have capacity to do so. Is this likely to change? Well, from the side of the law and the side of the statement, no. If therapeutic provision is named in an IDP, then it must be delivered as we just discussed. So that shouldn't change from the side of the law, nor should it change from the rights of the child. Obviously, in terms of the hiring practices of public bodies and health bodies, obviously that's something they will do internally. It's not governed by law itself. But I see no reason why they would change as a result of the law shifting, because, as we've just discussed, it is very much to keep the status quo that provision within a plan must be delivered and there is an enforceable right to it. So I wouldn't think there'd be any change. Our third question is from a parent, and it reads, my 10-year-old boy is on School Action Plus and has been for at least 2 years. I'm in the process of requesting a statutory assessment as there is no way he will cope in a mainstream comprehensive school. With the announced delay for IDPs for School Action Plus children, where will this leave my boy? So this is perhaps one of the direct consequences we've seen from the new transitional statement made by the Welsh Government in July, which has now pushed off those pupils who were on School Action Plus and were due to transfer pretty much straight away in September off to January 2022. Now, in this particular case, because the statutory assessment has already been requested or will shortly be requested, then that process will continue under the current system until its end, subject to the local authority agreeing to undertake an assessment. Now, the findings of that assessment will likely have been received by the time the Act is already in place. So you may find that instead of offering a statement, they'll use the findings of that assessment to transfer to an IDP, because the findings for special educational needs and additional learning needs are very much the same. So in this particular case, that should be the next step there if this assessment's been concluded. But of course, for those who are on School Action Plus, firstly, much like those with statements, if things are working well, you don't need to worry. Carry on with School Action Plus until it's transitioned over to the new format. Even if it's moved to the new format, that doesn't mean you need to get any more or any less provision. It's only important that the provision is right for that child. So if it's working, it doesn't need to change. And if it isn't working, then it's absolutely important that you're already taking those steps to open dialogues with the school or with the local authority, like this parent has here, to try and get things changed. So for the child in this case, either through the statutory assessment or very early in the next year through a request to the school, the change can be made earlier. Again, it's important to recognise that the rollout is scheduled to take place for, on an ongoing basis. So it's how the schools and the local authority are going to start transitioning people of their own volition, but the rights to request a decision, the rights to request a plan, those will still exist from the 1st of September. And for our final question, we have another parent question, which says, with all the delays, what happens to those about to go into years 11 and 13? Both statemented, one leaving to go to college rather than sixth form, one going to do foundation diploma prior to uni. So if these two boys were staying in school-based education, then actually nothing at all. Their statements would continue, as we've discussed during this seminar. And of course, they would still be entitled to provision therein. But there's a bit of a twist in the tale with this one, because they're both going to different institutions. So one is going to college. So colleges in Wales are not subject to statements under the current law as exists. They move across to a learning and skills plan under the Learning and Skills Act. So the local authority would have been the Welsh ministers, I should say, would have been under an obligation to start that process. It's normally undertaken through Careers Wales to create the learning and skills plan for college. So that should have taken place, although it wouldn't surprise me, given the pandemic and the legislative changes, if they didn't undertake that. So if they haven't undertaken that for the young man going to college, the right step would be to go and speak to the college straight away, notify them that he previously had a statement, confirm to them that you would like to have a plan, and move forward from there. At the college level, the college will be the first instance, as it is with schools. But unlike schools, you don't have the right to challenge a college's finding to the local authority. You can, however, ask the local authority to take over the plan, as we've talked about before. And you could very well, in these cases, particularly since both young people are statemented, look to do that, as often pupils with statements will have provision in their statements there'll be more than a college could deliver. So get in contact with the local authority, get in contact with the college, and start that process as soon as possible, because your statement will not be able to go with you to college. For the second young person who's doing a foundation diploma, it's not clear where that is. If it's like college, like their sibling, then yes, absolutely, the same process for the first child could be followed for the second child. But if they're going to higher education, then neither the new or the current systems would follow with them. There are different rights under the Equality Act for reasonable adjustments, both at the school level and university level, but they don't go as far as the provision you would find within a statement. It's more about providing some supplementary services. But there are grants for disabled students that are available at university, and often universities will have specific disability departments that you can contact that will help you apply for that funding to get the support you need. That could be equipment such as laptops or dictaphones. It could be additional tutors, it could be scribes, it could be all sorts, but it's actually tailored towards the needs of the individual. So if you're going to university, you won't get a statement and you won't get an individual development plan, but there are other means for you to get special educational provision at the university level. It will just be termed a different way.
Well, there it is. The new law in Wales. We've gone through it, and we've gone through it in some detail. We've answered some of your questions, and I'm sure many of you will have many questions to ask. And of course, please do, because we're here to help you. And drop us an email at education@sinclairslaw.co.uk, I should say. But thank you for watching our presentation. It's slightly different to the normal education magazine, because normally the education magazine we'll have guests on and we'll talk interactively about different things, not so technical really, but of course it was needed today because the law is fundamentally changing. So that kicks off our first edition of the education magazine, and of course my great thanks to Chris McFarland and to Charlotte for taking their time to help everyone today. Thank you both so very much for your assistance, and I hope to see you again back in our new series of the Education Magazine, which will be starting again hopefully in September. So if you've got any points you want to make or any stories you want to share with us, please feel free to contact us and just dropping us an email, education@sinclairslaw.co.uk. We'd be very, very happy to perhaps look at that and decide whether or not it's something we want to talk about. And there is a lot to talk about, of course, because we're coming out of a pandemic at the moment, at least the time we're recording this. I hope we're not going to go back into it. But I think we're looking more optimistically at our future now, and we've got a bit more liberty than we did have before. So looking forward to seeing you all again in September. Charlotte, thank you so much for your time. Grateful as always.
It was a pleasure.
And Chris, thank you. Hope to see you again in the magazine in September.
Thank you, Mike. Looking forward to coming back.
And thanks to you all for joining us, and look forward to seeing you again very soon.